welcome to another episode of Legal for Tech, the podcast. So, guys, you do recognize my voice here. It's always Rosie. And as I've said many, many times, we are just a group of students and young professionals who are here to speak about everything that has to do with technology. And yes, it's regulation. And I'm super happy today because we are starting something very important, which is season 2. And I know that you can see me, so now I'm going to move my hands even more because I'm also pushed in that direction. So that said, we have new friends, old friends. Today we have a very special friend, and he was here on the podcast beforehand. So I'm really, really happy to actually introduce him again to you. His name is Joost Gerritsen, and he comes from the Netherlands. Hello, Joost. Great to see you today.
Hi, Rosie, thank you for this wonderful introduction and awesome pronunciation. I mean, this is yeah, you're maybe partly Dutch. Is that one of the reasons? No.
No, I'm Italian 100%, as Italian
Italian.
100% is my co-host today, which I'm really, really happy to welcome here because he's a great friend and also he's a great, great, great co-host. Hello, Giacomo. Great to see you again.
Hi, Rosie. Very, very nice words. Too many, too many. Because you're also a great host. And hi, Jost. It's nice to see you again, even if I wasn't there, but it's really nice to meet you at this point.
Likewise.
So, Joost, I have to say, you've done something super cool, which you've just told us about. And I really wanted to share it with the whole public because I really am envious of you, not just because you have great hair, but also because I love your hair. I've always said that. But also because you have been at the Nordic Privacy Arena, haven't you?
Yes, I was lucky enough to be invited as one of the speakers. So, the Nordic Privacy Arena is a conference. Well, the name reveals it already. It is focused on the Nordics, so Norway, Denmark, Sweden, Finland. How they try to be more international, and I think they succeed in that because the lineup, if you look at the lineup of speakers, most of them, well, at least 50% was non-Nordic. So I'm, of course, I'm from the Netherlands, but I've also heard people speaking who came from America, the United States. I think also the UK and Germany. So yeah, although it is called the Nordic Privacy Arena, it is hosted in Stockholm. But I have when I went there, I got a really nice international vibe from it, and yeah, people speak English, so it's an English speaking conference. Highly recommended, I would say, for anyone interested in the data protection space. Um, or and maybe this is already a little bit of a hint about other topics we will touch upon. These only data protection, right? It's also Data Act, AI Act, Data Governance Act, European Health Data Space Regulation, and I think that was also one of the yeah, the main things I took away from that conference is that yeah, if you only focus on the GDPR alone, yeah, perhaps in certain respects it can be enough to do your job, but these days, no, more and more you have to take it into account other laws as well. So yeah, sorry, these were a lot of words. Long story short, it's a great conference. You should go there.
And we will definitely try to go at some point because we are trying to find some conference to go. And
Yeah,
you,
I
Mhm.
think for you guys it's really a match because yeah, I think Legal for Tech is really focused on yeah, it goes beyond the hype, right? I mean, yeah, Rosie just before we started the recording, we talked a little bit about LinkedIn, and then yeah, we have to admit that the LinkedIn posts, some of them, the quality is a bit deteriorating. Right. It's you see a lot of AI generated stuff, which is fine to a certain extent, but um, especially due to technologies as AI and others, it keeps it is harder and harder to find really quality content, and you guys offer that. I think that's a really great match with the Nordic Privacy Arena as well, because the organizing committee, they really do their best to to invite people over who have something to say on a specific topic. Maybe it's fun to say because, of course, I would like to talk about my own lectures I gave. But do you want to know other lectures I followed, which I thought were interesting? Maybe that's also something to
Do
share with
first
you
tell
guys.
us about what you
Okay,
what you
first I will tell about myself.
wrote about.
Thank you very much. I was there for two sessions. One was about, so I gave a lecture about um, case law that has been and case law that's probably coming. So, what's on the agenda of the Court of Justice of the EU? Case law that has been. Let me see if hopefully I can remember some cases. Well, of course, this was also one of the things you would like to talk about, right? The pseudonymization case, the SRB versus EDPS appeal case before the General Court. To be honest, although I've read the judgment, I haven't really, how to say, studied it because I did a search, a search for the main topic, at least the pseudonym. Do you guys also find this is difficult word? Pseudonymous.
We
It is.
actually we took a small course within Legal for Tech to actually pronounce these words
Yeah.
because we were very, very confused. So we had anonymization, pseudonymization. We actually had to
Pseudonymization.
train.
Oh, excellent. I wish I could attend that course as well. Now, even if I had to
Next
write,
time we'll open the gates.
yeah, thank you very much. But no, so I think everybody knows this, but quick recap for the listeners. So when we apply the GDPR, one of the main things you want to know is when are you dealing with personal data? I mean, if you're not dealing with personal data, GDPR does not apply. You can forget the whole law, etc. So that's quite an important question. Still, after all those years of data protection laws, legal scholars and judges and privacy practitioners are still debating with each other how to apply the term of personal data. And I think, in a nutshell, the European Data Protection Supervisor, but also a lot of other supervisory authorities and other intelligent people, they made several statements about personal data, one of which is that pseudonymous data are always personal data. And I think a lot of us worked past years under that assumption as well. And others be is more complicated question about okay, if you have a data set, from what perspective should you regard those data as personal data? Is that the controller's perspective? Is it the recipient's perspective? It's true. It is possible, at least theoretically and now also legally, as confirmed by the court, that even though the controller, from his or her perspective, those data are personal, so the GDPR applies. If you take the perspective from the recipient and the recipient only has pseudonymous data, then yeah, you could argue that in certain cases, certain scenarios, those data are not personal data. What consequences will that have? I'm still not fully sure about what this means in practice. But yeah, to start with the first point, are all pseudonymous data automatically personal data? Court is now really clear, says no, that's not how it works. You have to assess that on a case-by-case basis, which I think is logical, but we data protection professionals have been taught otherwise for the past 10, 15 years. So that is quite something. What do you guys make of it? Because I can talk on and on about this, but I'm also wondering, have you thought about these consequences? If indeed you have two parties, for the sending party, these are personal data, but due to pseudonymization and technical and organizational measures, for the recipient, those data are not personal in nature. Do you have any idea how to deal with it?
Actually, so I have 2 points on this. Firstly, I have to say I have a very, very well prepped colleague on this point, David Wagner, Aspire Legal, and I have to say he made a very, very clear kind of point on this. in which he did explain, like, yes, okay, pseudonymous data don't necessarily need to be identifiable. So that was the whole point of the situation. I guess that's also the whole point of the judgment. I am a bit skeptical / concerned about how this kind of obvious decision, which is like, okay, if you don't have the way to identify them, they can be non-personal because it makes sense, can be used to kind of walk around the need for being extremely, like, obviously keeping security and keeping up with the obligations under the GDPR. I was reading a paper actually a couple of days ago, which was about this idea that pets, so privacy enhancing techniques and technologies, can actually be used to avoid actually respecting and fulfilling the obligations under the GDPR because it's less expensive. So if you say like, yeah, I don't really do GDPR, but I do something kind of similar that kind of has the same effect, you should be able to completely avoid the actual obligations that are there to safeguard personal data and ultimately the rights of the data subject. And I'm a bit concerned that this kind of, like, I would like to use a very professional sentence, ping pong between between processor and controller and pseudonymous and non-pseudonymous could become kind of like a football scheme to actually score the goal and avoid respecting the GDPR. I'm referring to the famous technique of tiki-taka that's also very Italian and
Yeah.
also very beloved
No.
between our nationals.
Yeah, no, we as
But
Dutchies we always have a very hard time playing football against you guys, but that's another story. Um, yeah, I totally get where what you mean, and I share your concerns. But because that's also my feeling that okay, now we have a clear understanding of how to apply these legal criteria regarding a certain data set and whether or not they are personal data. But I am dreading the scenario in which, let's say, a client comes to a lawyer and says, "Oh, we have pseudonymous data." And the lawyer checks it based on the criteria of this court case. And then the lawyer says, no, you are in the clear. These data are not only pseudonymous, but thanks to additional measures, we can conclude those data are not personal in nature. So the GDPR does not apply. Then, of course, the client is very happy and says, oh, okay, we'll forget about the GDPR. We'll do other stuff, but we're not going to secure the data any further, or we're not going to respect data protection rights in any other way. But then, for instance, the data end up due to a hack on the internet, and people who are handy, who can connect and analyze those data, the data set changes its color, so to speak, and it becomes personal in nature. And then we have a problem because yeah, back then the client was advised that GDPR does not apply. Just go on a holiday or whatever. But now the data are identifiable, and there is a problem, real problem for data subjects. So I'm a bit scared that this court case could lead to unsafe scenarios, if that's a correct word, that people are too quickly drawing conclusions about, yes, finally we escaped the GDPR somehow. That's at least what I'm afraid of. Do you share this, or are you a little bit more optimistic?
I I also think that, like, when you have means like LLMs that can infer kind of correlations very, very easily, potentially getting a lot of slightly less identifiable personal data around online could be dangerous. But I I agree with you. Like, I understand the judgment of the court. I understand the reason why sometimes the GDPR obligations can be scary. Um, I'm not a person that likes the kind of midways. I'm very either or. So I'd rather be a bit more compliant and a bit safer around than, better safe than sorry. But maybe
Yeah,
we'll
that's
be proven
also
wrong.
that. No, exactly. That's also how I at least advise my clients. And on LinkedIn, I saw quite a lot of lawyers who said so the SRB versus EDPS appeal judgment was published, and quite a lot of lawyers said, "Oh yeah, this is something I've been saying for years and years already." And then I think, yeah, what do you want to say with such a statement? Because all the supervisory authorities said something otherwise. So in practice, if you at least if you are a good lawyer, I'm now just dissing everybody who did,
That's a
but
great way to make a judgment about people.
but
It's like,
but
if you are a good lawyer and if you
yeah,
say that, like,
no, but if you
connect
are
the dots.
yeah, no, but if you're a good lawyer, at least that's how I always advised, is that you say something like, okay, I personally think if we apply the law, it's not personal data, but still we live in the reality of the supervisory authorities. You know, those are the same guys who can impose a fine on you, so we have to be friends with them some way. They say something otherwise. So that's why in the past 15 years, I have advised uh, not based on what the court just said. Yeah, of course, now I will. But in the past 15 years, I didn't because we lived in the reality of supervisory authorities who had a different view and basically said pseudonymous data are always personal data. And not only that, the controller's perspective, the main perspective you should take when assessing whether or not the data set is personal in nature. So I think it's very, if you are a lawyer and as a reaction to this court case, you say, "Oh, this is something I've always said." So then I hope you didn't say so to your clients with the conclusion, just follow me and ignore the supervisory authorities, because that would be, I think, a very risky move, and that's not the way I practiced law. But that's
Oh,
personal. That's personal. Um, yeah, that's
I
just
do
how.
see some skeleton in the wardrobes.
Wait, sorry.
I
What does
do
that mean?
see some potential for some tiny little secrets hidden back that you just uncovered completely. We will
Really?
see. We will see. I feel potential for litigation actually, but we will see. We will see.
Potential litigation? Sorry, I'm not following.
We will see. We will see if these lawyers actually did advise the clients wrong because.
Ah, yeah. We'll see. I always think, well, I hope that they are very well insured, that they have a very good personal insurance for bad legal advice. Yeah, okay, but that's just me. But from now on, I could say to clients, okay, now finally we have the SRB versus EDPS appeal. Luckily for you, it is quite nuanced regarding whether or not data could be personal data in nature. Um, and I think also the EPS and other supervisory authorities have to admit that their view, well, was not in line with the law. Um, and then, of course, you can advise in a different direction. But still, then I come to the first section of what we already discussed. I'm still a bit hesitant to say, oh, you can just mind your own business right now because the GDPR does not apply, because I think that's too scary. That's okay. That's me. Uh, uh, Giacomo, do you have any additions? How would you advise clients?
I'm stopping the lawyers chatting here because I'm not a lawyer, so I will stop that. No, jokes apart. Uh, I was wondering like if so data are categorized as not personal, do other legislations apply? Like for example, what about the Data Act that is now enforceable?
Yeah, very good remark. Because yeah, what we see more and more is that yeah, traditionally European laws were about regulating personal data. Most notably, we have the GDPR, but before that, of course, the Data Protection Directive. More and more, we see this term non-personal data popping up in all kinds of laws. meaning data which are not personal data. So that can be a lot of types of data. Recently, from the top of my head, on the 12th of September, the Data Act applied, and yes, that law doesn't really care or doesn't care at all whether or not data are personal. Now, those are about data in relation to so-called connected products, or yeah, I would say Internet of Things kind of stuff like smart household appliances, a smartwatch, smart thermostat, but also your car. I mean, if you would buy a car today, it is a modern car connected to the internet with all these data and sensors and whatnot. All those products and their data are covered by the Data Act. So indeed, Giacomo, we can discuss all day long about whether or not some data are personal, but the Data Act doesn't care about that at all. So yeah, non-personal data, I think that's quite a thing. It was already a definition in a regulation called the free flow of non-personal data. It's not a very well-known piece of law, but has been introduced a few years ago. But you see it now more and more in several laws. So yeah, maybe the whole discussion it is still interesting because yeah, if data are personal data, then you have to deal with data subjects. But if you conclude how these data are not personal data, it's not the end of the story. Data Act can still apply, other laws can still apply. Yeah, so yeah.
I mean, the Data Act, I think, is particularly interesting because, like, it does talk about different concepts, which I feel like, I mean, of course, they were never at the center point of the GDPR. Things like interoperability is like, yeah, okay, there is like half a provision or something, but it wasn't the core of the GDPR. What I find kind of interesting and sometimes slightly unrealistic about the Data Act is this idea that your data can be kind of moved around, but also used for commercial purposes. So, like, technically, this idea of like you can sell your data
Yeah. Yeah, that's
because,
yeah.
yeah. What do you think about that?
Yeah, very good question. And I noticed that I understand that feeling that at least there again, people on LinkedIn are quite shocked when they finally understood what the Data Act is about. So maybe just for the listener, a short recap. The Data Act. No, I have to start in a different way. We already knew or have legislation in Europe that regulates data from government entities. And the idea about that is that those data within the boundaries of a government entity is being made or should be made available to everyone, businesses, citizens, for main reason, what they call it a reuse of public sector information. Why? Because it has a lot of economic value. So this is just simple example. You have the meteorological station in the Netherlands. It's called the KNMI. I think every country has one like official government instance that, among other things, predicts the weather, right? Whether or not in the Netherlands it's usually rain. In Munich right now it is sunny, but they analyze it. Oh, no, more or less, they analyze a lot of data, and they based on the data they issue a weather prediction. Those are government data because this has been done by government. The data has been registered by government-owned stations everywhere in the world. And the idea is that those data have a lot of value in it. And if we make it available to businesses, they can build apps on top of it, or software, or other types of appliances, which is good for economy. So in the Netherlands, we have this company called, yeah, literal translation would be rain radar, because Dutch people are always obsessed about when and where it will rain. So we have on everybody has this app on his phone. For the Dutch people, Buienradar, you know this. Um, this app shows you very precisely where it's going to rain. But the people from Buienradar did not record or register all those data themselves. No, they buy or use the data from the government. Sorry, they don't buy it, they just retrieve it. Why? Because based on the Open Data Directive, this should be made possible. Okay, so we already have a tradition of governments making data available to the outside world for economic purposes. On top of that, after the Open Data Directive, a few years ago, there was like an accompanying law, extra law on top of that called the Data Governance Act. But we will probably devote another session about that act. Anyways, Open Data Act, Data Governance Act, regulating government data. You could say this is only one part of the coin. There's another side, which is data held by businesses. Business data are very valuable for the same reasons. Others could make services on top of it or combine it with their own data, etc. But that part of business data was not regulated in the EU. And that's what the whole Data Act is about, that we are going to regulate those business data. And a lot of people, and of course, they are truly correct if they say that is that the Data Act regulates Internet of Things. But if you read closely, it has different chapters, and it also regulates all other kinds of stuff. Like you said, interoperability is a huge topic. I think I've never seen it described in such a lengthy way until now. So interoperability, also for the listeners who are not that into legal stuff, is about the notion that if you have like two data spaces or two networks or two databases, whatever, that they can communicate with each other, and you have to make rules about that of what will be the rules of that communication. Sounds very simple. It is not. Luckily, there are now rules about interoperability, so that you can connect all that stuff. And yeah, now we have the Data Act. And if we zoom in on the first subject, the Internet of Things, so the smart house, smart appliances, for instance, but also your connected car or, I don't know, even airplanes or robots are part of it. Those products all, yeah, how to say, emit data if you use them. And those data can be very helpful. For example, if you are in the repairing business, you repair cars. You want to know the state of the car, and you can do that by analyzing the car. These days, it all goes with computers, right? So you plug in the car in the computer system, and the computer system will tell you, as a repair guy, what's wrong with it. But those data are owned, so to speak, by the manufacturer. So this Data Act forces manufacturers of connected products to make those data available to everybody, to citizens, to businesses, to whoever wants it. And yeah, those data can be personal in nature. So this is, I understand that people are a bit wary about this whole ordeal. So yeah, okay, where is this data going? Yeah, the Data Act says if there's any tension with the GDPR, the GDPR should prevail. But yeah, I'm not so sure how this will play out in practice.
The thing is, like, is it important whether the data is actually personal for like giving it a huge value and most importantly, to have it have a direct effect upon people? Because what I'm a bit concerned about is like, we're talking about Internet of Things, right? And your car knows exactly where you're going, right? It doesn't matter if the car knows that that is Rosalia's car and Rosalia has gone A to B or does go A to B 5 times per week or per day or whatever. What it matters is like probably Rosalia driving a BMW, don't ask me why, um, means that there is some BMW that drives from A to B every single day, and that potentially, if I do drive a BMW, I have a slightly higher economic status because BMWs are expensive. And so, for example, you could place there from A to B an advertisement that would definitely appeal to me. And it doesn't matter if that is potentially just my data. What matters is that you have access to the location of a given car at a given place on a huge scale. I'm just a bit concerned about the effect that having access anyways to data, whether they are personal or not, that can be aggregated to this level is fair to the consumer or to the user, even to the business anyways. That's just my question.
It raises a lot of privacy questions, privacy-related questions. Yeah, for the Data Act, it doesn't really matter whether or not those data are personal or non-personal. It only, this is really short. If you want, maybe perhaps it's a good idea to make the listener aware of my article. So right now, this is a podcast, so I'm not telling you all the details. So if you listen to this and like, oh, Joost, you are wrong, well, please read my article first, then. And if you then still think I'm wrong, please send me a message because I can be. That's perfectly fine. Yeah. So I have this article written, peer reviewed. So other people looked at it as well, about the Data Act, where I lay down just the act itself. I explain it. People can, yeah, if you just can contact me or Rosalie or whatever, we'll make it available. Yeah, this is no problem. So what I'm going to say here is just a general take on data protection and the Data Act. But I think the Data Act, it has some provisions that try to protect data in the same way it does the GDPR with personal data. But no, it's really about in its core, it's really about making data available. So that's quite the opposite.
Mm.
It has to be in the outside world. For anyone to use, you can actually also demand that as a user, so you are the user of a vehicle, you can demand Tesla to Tesla, for example, or BMW, that the data are not sent to you as a vehicle driver, but to a third party because you want to make available the service of so you want to use the services of the third party, so you can actually order or request the vehicle manufacturer to send the data to another party, so-called third party. Um, this is all can raise all kind of complex questions, because if we talk about vehicles and you're talking about location data, these are not also potentially the location data of the driver, but also from the people inside the car, right, who are also part of the journey. And then you see, I think this is quite funny, is that the Data Act makes clear that, yeah, well, in those cases, you must always have a legal ground. It almost says literally that a legal ground in the sense of GDPR. In practice, that will be consent. I think the only real logical legal ground we have here. But how does that work in practice? You have to ask all the people inside your car, hey, I want to use this third-party app with location data of my car. Do you guys agree? And there's also a toddler in the back. That kid doesn't know anything. Luckily, hopefully, you are the parent of the toddler. You can do the consent on his or her behalf. Or no, it raises all these complex questions from a data protection perspective. And the Data Act does not answer those questions. It only says, yeah, well, if there's any tension between this act and the GDPR prevails. I think it's a bit easy to just, how do you say, move the problem outside the
Yeah.
Data Act. Yeah,
Especially because legal bases from the GDPR are always so clear
yeah,
that there would never be an issue in trying to understand which one prevails and which one's better. I am
yeah.
sure that everyone would know which legal basis to use because of the GDPR.
Hopefully. Hopefully. And there's another thing I just reminded that the Data Act has like some sort of blanket statement that the data from a connected product, so in this case, the vehicle we are talking about, those data may only be used in line with the purposes and the conditions, yeah, between the user and the manufacturer. But at the same time, like I said, third parties are also eligible to receive those data. And then it has a strange, I think, provision. I think the guy or girl who wrote this thought, oh yeah, but maybe that can be like an extra risk, right? But so you have a third party with potentially, yeah, privacy of personal data or otherwise raise privacy issues. And so the legislator then said, yeah, well, that third party is not allowed to use the data for profiling. Okay, it sounds good. And then the sentence ends with, yeah, but unless the profiling is necessary for the service. So, okay, can you use it for profiling? Yes or no? For me, it is unclear. And that's I think that through and through all those provisions, you see that the mindset is totally different. It's not about data protection. It's about data making available to everyone, including third parties.
Mm.
And then you, of course, you see a legislator knows or heard something about the term profiling and think, oh yeah, profiling is scary. Don't use it for profiling. And then, oh yeah, but maybe profiling is necessary. So okay, you can do it. And then so this is a
Yeah,
big shock
but
for data protection people.
but then if you're a big company, then you can't do it. You can't aggregate data because of the DMA. So like,
Yeah, there's also yeah
yeah,
there is also are you hinting on there is indeed a special provision that refers to the DMA that's one the one you mean, right?
yeah,
So on
it's all a bit messed up.
yeah, so I can explain, or do you want to explain it?
No. I trust your article more than
No,
my memory.
yeah. So if I'm hopefully because I've read it, I wrote the article this summer, but somehow I don't know how about you guys, but if you write an article, for me, when it's done, it leaves my head. It is
For
as
me,
if
it
I
loses my head while I'm writing it, which is problematic. But
yeah, well, that's another problem. But no, in this case, so when we talked about making data available, you could to everyone, and you've read the newspaper. Maybe Giacomo, this is, I think, also for you from your perspective interesting because this ties into the whole data as a political subject matter. So what I want to say is that when we talked about data making it available to everyone, you might think making it available to Google as well, or Alphabet, to Meta, to ByteDance, right, a company by TikTok. Do those guys don't have enough data? When is enough enough? And I think the legislator at some point thought the same. They thought, if we make it available to everyone, we're making it available to big Chinese companies as well, and to big American companies as well. That's not what we want for all kinds of trade related reasons. So they put in a provision that says, well, uh, this is my paraphrasation, those data should not end up in the hands of the so-called gatekeepers who are designated as such under the Digital Market Act. So I think from the top of my head, do you know the list of gatekeepers from by
yeah,
heart?
it's seven.
Okay,
So it
seven.
should be Alphabet, Apple, Meta, I am sure.
Yeah, Microsoft.
ByteDance is one. Microsoft is one.
Yeah, two,
Uh,
two
let me
left.
say Amazon is. Did I say
Oh
Amazon?
yeah,
I didn't say Amazon.
yeah, no, yeah, yeah. I'm just
uh,
frantically googling. No, there
Google
were
is Alphabet. So like, I think I said.
or,
Uh, um, um,
originally there were six, but now
they
it
are now
is.
seven. I'm sure because I searched up
Oh,
yesterday.
oh, this one. I wouldn't guess this one. Do you know it? It starts with a B.
Cooking? No.
Yes.
You are a genius. How did you do that?
Booking,
But there are,
but
I think, 23 core services if you want to.
Giacomo, for now, I think this is your moment to shine, given your background. What do you make of this? Well, the Data Act legislator tries to keep those gatekeepers like Booking, but also Google, etc., outside the realm of yeah, data sharing. This is highly political, right?
Yeah. It's super political indeed, and it's super interesting to be honest. I mean, it's really, really legal language from time to time, so it's a bit difficult for me to understand like this kind of topics, but they're super super relevant, and yeah, so it's amazing to hear from your point of view as well.
And what do you think? Because that is also something that voice is going getting louder and louder. That on the one hand, so of course we have seen messages from Trump and and his friends that they are very critical about the legislation in Europe and it hinders American companies like Google, like Microsoft, etc. On the one hand, the European voice is that, yeah, well, but you guys profited a lot from our internal market. Also, because of those Open Data Directive legislation, which, like I explained, made government data, European governments, where they didn't pay, well, they do pay taxes, but they, no, not a lot for those governments to exist. European government data was also used by Google and is still used by Google, and they don't pay any cents for it. So I think yeah. How do you see this? What's your personal take? Do you think that the American companies have a fair point, or do you think, well, maybe
I think,
enough is enough?
am I also the only one that sees that the DMA can be easily walked around by one simple thing?
Oh,
It
how?
says it says the gatekeepers, and also the Data Act talks about the gatekeepers and strictly for the core services. So my point is, what if you're at Google DeepMind? Like it's that's not the core service. Like OpenAI is not there.
Yeah, yeah,
It's,
yeah. I think I read this somewhere.
Meta Llama is not there. Like because it's the core service of Facebook and Instagram. But does Llama also apply? Not sure because AI wasn't out in 2022.
Yeah, this is very good, very well spotted. I think when I wrote this article, I remember something, but I'm not sure whether or not I read it in the recitals or in the frequently asked questions of the commission. Those are, by the way, I would
But
recommend anyone reading those. And there was something like in this context of gatekeepers. Uh, the idea that yeah, but the data should also not end up within their subsidiaries or like ancillary activities. I think that was the idea.
sure, sure. Firstly, I mean, I would point out that unless the commission actually does its job and names the services, their frequently asked questions have the validity of this podcast, more or less. We're actually better. But also, I don't think any member of the commission is going to come on this podcast. But also, I love how we're all laughing at this. Great. But also, no, I wanted to say it's difficult in some cases. Like if you see the American cases, for example, of the parent companies of something like Character AI being led back to Google, it's very difficult to demonstrate subsidiarity. And I'm sure that like laws in Europe are a bit different from the American ones. They do have this kind of corporate liability idea. That's kind of like taken from the British. It's really completely different from ours. But at the same time, I do believe that anything that has a very strictly named list of things can be easily worked around. So I'm not sure. We'll see. That's my
Yeah,
point. But
yeah. Well, I think one thing is for sure. Yeah, you raise a really valid point. One thing is for sure, the gatekeepers we are talking about, they will contest any and all of this. They will try to get those Data Act data as well, and they will give you 50 arguments why they're perfectly lawful to do to receive those data. And if not, they will go to court and they will fight with the commission. For them, it's no problem to do all of that because yeah, the data are really valuable. And yeah, their lawyers are now thinking really hard about how to circumvent any of those provisions hindering them from this Data Act data. Yeah, but valid point. So, yeah, are there ways for the DMA gatekeepers to receive Data Act data in any way? Yeah, could very well be. Good point, Rosalie. I haven't thought about it really.
Yeah,
Someone should research this.
and by the way, about the DMA and AI thing that we were discussing before, I remember that the Commission just opened like some sort of consultation to a review of the DMA right now. So I think they probably want to try to insert these AI providers and so on. So, but it's not gonna be like it's gonna be like a long time before we reach like a real law. So yeah.
Do you think, so if I understand you correctly, Giacomo, they're already trying to, well, revise the DMA or evaluate it, but do they do it with the mindset we are going to expand the list of gatekeepers or we are going to make it shorter?
I think so. I think so because as far as I remember, I was reading like the consultation, and they were talking about the implications for the artificial intelligence sector. So probably they will try to
I mean,
tackle that, and it depends also from the organization that are giving like the feedbacks on that if they want to
they
include that
also
or
have
not.
to do it on a yearly basis, don't they? So like it's a year has
Yeah.
passed since 2024 September,
Yeah.
whenever the DMA was entered into force. So I guess that they have to do it like in terms of they have to rethink of the list
Mhm.
gatekeepers, if
So
I'm not
this
mistaken.
is something different compared to, yeah, you also have this AI Act stop the clock discussion. Several member states are about, yeah, for them the AI Act, it goes too fast and they want to pause it in a certain respect. That's something different, right? So you are talking about the regular evaluation,
Yeah. 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 Different.
and
Different.
I think
It's not a revision. It's like their annual report every
oh,
year.
I see. Yeah, but I mean, the DMA, you guys know this better than me, I think. Those gatekeepers, they contested probably their label as gatekeeper with success. Yes, no,
X
has this
did.
happened?
X actually managed, and
Yeah.
they got removed from the list. And if
Uh-huh.
I'm not mistaken, also Facebook Marketplace as a core service
Ah,
got removed, but
okay.
not Meta in general, because Facebook is still an online network provider and it's still in the list for that core service,
I
if I'm
see.
not mistaken.
I see. And then we have, of
So,
course, but that's a
awesome.
different scope, Digital Services Act, so that regulates platforms. A lot of those
That's for
gatekeepers,
platforms. That
yeah,
it doesn't regulate the provider, it regulates the
no,
product in like
yeah,
we can't call it product, but like you get my point.
yeah, but there is a certain overlap, right, between the gatekeepers, some of their
They're the
core,
same. Like
they're
the
all the
ones
same.
that are gatekeepers
Uh-huh.
actually happen to have services regulated under the DSA.
I see, I see. And a
So
lot
like the
of,
doesn't.
yeah, no, I understand. And if you read the newspaper from time to time, you see that if regarding the DSA, a lot of these companies have big problems with it. And then I think that the DSA does a really good job, right? I mean, uh,
I think that it's easier to argue on freedom of speech than arguing on competition. So I think that companies do exploit the DSA to go against European regulation because it's so hype and it's so great for American and
mm,
sometimes Chinese narrative, I would say.
yeah.
So I do think that they're exploiting the narrative because it's much more relatable than like, oh, it's competition problem. Oh, great. What is it? It's like, do
And,
you
and,
even know
uh,
what competition is? Like,
And are you guys, because this is just this is an idea. If it's nothing, we can cut it out the podcast. But I was wondering, there more and more I see a crossover between GDPR and DSA. I think there are two regulators in Europe and supervisory authorities that say something like, "Hey, what you are doing, for example, Facebook, your terms and conditions infringe the GDPR, and thus are also DSA infringements." because the DSA says that your terms and conditions have to be in line with EU law. Have you heard about this?
Yeah, I'm so sorry. Interesting people around Munich today. I guess it's the Oktoberfest. Um, but no, I can tell you something about that because actually, I was talking about this at a project that was provided in Riga last
Uh-huh.
week, actually,
Yeah, yeah,
and I can tell you that the litigations that law firms such as Legal brought before courts here in Germany, but also in other courts around the European Union, did exploit kind of the framework of the GDPR talking about profiling to then say, and that's also a violation of the DSA. So they used the profiling. They said these firms, these companies do profiling. Thereafter, they're also breaching the DSA articles 28, 26, and also 34, 35, if you think about systemic risk.
yeah,
So
yeah,
I get your point because I actually read
yeah.
the acts and I can tell you that a lot of especially private enforcement is going around there. So like you use my data, you
Yeah,
profiled me. That was
yeah.
not that was not allowed under the GDPR, and that's also not allowed under the DSA.
Ah, I see. I
So
see. Ah, okay. And what was the conference called in Riga or the meeting?
yeah, so it was called React Pilot, and it was organized by, I think, Sinalagma, which is a consultancy firm that's also helping consumer associations such as Euroconsumers and Altro Consumo. We've had some of them here on the podcast as well, so I really, really, really do recommend listening to those episodes as well. With, for example, Marco Cialdoni, Marco Pirani, the great friends of the podcast, also Els Bruggemann. And see, a bit of plugging. But yeah, it was really interesting. There were four consumer associations from around the European Union, and we were talking about the way that the DSA, especially, can be enforced privately through class actions. So talking about the
Yeah.
kind of interlap between the DSA and the Collective Representation Directive, or RAD, which are also the initials of my name. So I really like that
Ah,
directive.
yeah, yeah, yeah. Oh, nice. Double win-win. No, very interesting. So, I'm sure you guys will pick up this topic for another time, right? Because there's so much more to say about this, yeah, GDPR DSA crossover. Yeah, I just highlighted it because I see it more and more, and yeah, the fact that you can just already name so many people who are also thinking about this longer than me, yeah, it's a testimony that it will get bigger, right? This crossover.
I really do hope that some of these cases are going to get to the CJU.
Yeah, I hope so.
Because I think it's a problem that needs to be addressed by a European court, not just by, obviously, national judges are great, but I think we need a unified response
Yeah.
because the academia is thinking about that, of course, but what's that in practice? What's that when you think about damages, for example? Which one prevails? Do you do 50-50? Do you get both? Eh,
Yeah,
big issues.
good stuff. Do we have time left for a question? What do you want to ask me? Because we're, I think, now talking for
I
one
will,
hour.
yep, I will ask you the last question before
Yeah,
letting you go,
yeah.
which is firstly, how's DG Beetle going?
Yeah.
Because I'm seeing it
Ah,
around.
very well. Yeah. So, yeah, what we try with DGB tool is offering a platform for data protection professionals who want to be up to date regarding case law, supervisory authority documents, the laws of what we like to call these days the EU Digital Rulebook. Talked about the Data Act, of course, GDPR, DSA, it's all there. It is going very well. I'm quite proud of it. These days, more and more supervisory authorities are using it, and I think I can explain that because for them the world can also feel overwhelming and they have to stay on top of things, right? I mean, now we have this SRB versus EDPS appeal judgment. they have to be aware of that because the last 15 years, as we discussed, they put out all different notion of pseudonymous data. So they have to aware that the world has changed, and I think more and more of those authorities are getting up to speed. So that I'm really grateful for that. Also, I want to highlight that we work together with the kind people of the Brussels University PhD researchers who help us with so-called expert explainers. And so this is the people side, and I think people are still the best source if you're looking for intelligence. But sometimes you want to do something quickly. So, for example, when I put something on LinkedIn, yes, I read the judgment, but it's also really helpful that an AI tool can help you with something like a summary. So that's also a development. We're not blindsided. How to say, we're not like an ostrich putting our head in the sand. No, very soon we will open up the platform so you can connect it with your favorite AI tool. And I'm already using it in a beta stage, so to test it out. And I
Ooh.
think, yeah, it is so nice because you just highlight the topic of let's say right to compensation, and on the platform you can just filter it on the topic, and you then feed your tool. My favorite tool is Claude, for example. I don't know. Do we have a favorite AI tool? Maybe ChatGPT or
Ooh. I have to say, Claude is
Claude?
particularly well behaved,
Yes. Well, they.
I would say.
I
That's
really
fair.
like Perplexity.
Oh, Perplexity. Oh,
Because you
Yeah,
yeah.
can have
Yeah.
all of them on Perplexity, if I'm not mistaken,
yeah.
right?
Which that is owned by Amazon, or
I don't
Perplexity,
remember,
isn't it
to be
still
honest.
privately owned? I think so.
Yeah, I think
but
so. Yeah.
I think that's the best thing about it is that you can feed the information in your favorite tool, so that doesn't really matter what you use. And I think the answers now. So if you, for example, if you would ask Claude just from a blank slate, dear Claude, what is the current state of play regarding right to compensation in light of the Court of Justice judgments? It maybe it will produce more or less okay answer, but to be honest, Claude does not know the most recent judgments. It doesn't also know the most important because, yeah, it just looks on the internet. For Claude, any source is equally as important. But I think especially the tandem, the combination between a human, the user of digital tool, uh, making his or her own package of information with only the sources he trusts, and send that to the AI tool, of course, instructing the AI to use only this information. During the beta test, it already yielded very good results.
Ooh.
I would never copy paste it directly to a client because I'm a control freak and I want to read it as well for myself. But if you want to use it, for example, a LinkedIn post or blog post or newsletter, then you can quickly get to, I think, yeah, information which you can copy and paste. And for the more critical assignments, for example, if you have to advise a client, then Claude or your other tool of your liking really helps to save you just a lot of time because, yeah, you can read 20 judgments about the right to compensation, or you can just ask Claude a question like, what type of damages got compensated in these 20 judgments? It will save you hours, hours, hours. Hopefully, we will use that free time to go on a holiday or sit on the beach. But I'm afraid we will use that time to work even more. But maybe that's an all different topic. But no, all jokes aside, the first results are really yeah, I'm really happy about it. And the platform, just to circle back, is that we invest in the knowledge and in the high quality content. So you can use it any way you like. So you can use it with using an AI tool, or you can just I don't know, watch one of our webinars or whatever. So long story short, it goes well, and hopefully it will get any better. Still, yeah, even better.
I am really, really happy to hear that. Just to conclude this amazing conversation, I will give you a couple of plugs for our listeners. First plug is you will find the link to Joost's article here in the show notes, and you will definitely be able to find Joost as well, because we will tag him when we will publish the podcast. So in case you actually want to ask him why he came up with such great ideas, you can actually do it by DM him as he suggested. And then great plug, please do visit Digibito. Is a great platform for getting very important information. I use it every time as well. And I would also advise Joost to let us know when finally this new tool will be available, because you can bet that I can't wait to use it. So I will probably use my Happy Claude, who is very friendly to me, and potentially let you know how it works. So thank you very much for joining us, Joost. It was a pleasure to see you again. And thank you for opening this season for us.
It was a real pleasure. Thank you for letting me have the honor of being the first guest of the new season. I wish you guys, everyone in the Legal for Tech team, all the best and good luck with this season. I will be a listener for the rest of the episodes, and I can't wait what you guys have in store for us. So thank you very much.
Thank you so much. And thank you so much, Giacomo, for joining us today, because I mean, the person behind everything here is really Giacomo. I'm just talking.
Thank you. Thank you both. It was super interesting.
Thank you. And this was all from Legal for Tech, the podcast, season 2.